Procedural also. First, I beg to mention item number 5 the daily list also. Item number 5. Only adjourn this matter only for today also.
Item 5, which is a representative.
Taking the consent of the other side also. We are already taking the consent of the other side.
Since you have given an adjournment slip, we have no difficulty in adjourning. Both sides are represented. Declared made by Miss
CM Decalogs.
CM Deca, the Human Council on behalf of Mr. Arpan. Then council to be attached to the assistant don't be this documents. Yes.
Obliged.
Item number 3, my lord. Can it be on late field? I have to prove I have two difficulty in it. See, we are not adjourning because you did not give an advance slip. On Tuesdays and Thursdays, if you are not giving advance slip, we find it very difficult to adjourn. We are keeping less cases and therefore my adjourning will not help us.
Daily list item 1 for admission.
Mr. Fine. You know, matter we heard yesterday.
Yes.
Of Stan Bora.
Yes.
We have to issue notice. There's some problem with the order.
My lord. My lord, in this point. Very good. Thanks.
Yes. We need to start from the beginning because my esteemed other may not be aware of what has transpired.
Not. My lord, in this matter, Mr. Lordship has directed to file an written argument with the chronological list of dates.
No, but
I
you have to tell
prepared.
the facts because my esteemed other is not aware of
Yes, my lord.
facts or circumstances of the case.
In this matter, my lord, in 7/7/12, my lord, my father. Seven, seven. Yes, yes, my lord, yes, yes, my lord. Yes, my lord. When this matter, my lord, my father was picked up at 12:30 on 7/7/2012 by the respondent number 6, my lord. Though he is not an apparent accused, they have charged, entered my house and charged my brothers, Nizamuddin. Not finding my brother, my lord, they picked up my father, who is 60 years old at that moment, my lord. And very next day morning, we came to know that he declared bad in the custody, my lord. And while he was picked, during the course of period, my lord, the magistrate inquiry conducted, my lord. And did a magistrate inquiry, my lord, it's found that some witnesses were examined, and most importantly, 3 eyewitnesses were there. Categorically, my lord, stated that there is the concerned person who arrested, that he is give a jerk with his head, my lord. And when he lost his consciousness, after he was taken to Silchar Medical College Hospital. There initially it is recorded he is found dead, brought dead. Subsequently, it is wiped out and other record placed there. And accordingly, my lord, It is also statement by the doctors that while he was sent to Central Medical Hospital, the police van, my lord, not in the ambulance, my lord. There is no oxygen is available at that time. During course of inquiry, my lord, the police personnel has twice final report placed. Both the occasion learned trial court below rejected on filing of objection. Now we have been directed to file a complaint against the to restart the proceeding again, my lord. And the postmortem report made the next year, my lord, by the respondent number 1. It is there that postmortem. In the postmortem report, my lord, in a respondent file, it is found the victim showing cause of death of syncope. On 33/2013, there is judicially inquiry report is there, it said it the violation of section 50 and 50A, admittedly, And on the last occasion, I have verified the records. And from record is this, I have found, there is no report so far as any entry so far as my father's arrest is concerned, in the record. I've seen, in the last occasion, this honorable court is directed to verify the record. I have seen the record, my lord. There is no report in the JD entry, my lord, regarding my arrest, my lord, my father's arrest. My lord. I have marked in some flag mark. I have marked it. Surprisingly, they visited to my house, our house, and inquired about my brother Nizamuddin. On not finding, they picked up my father, and according to my father died. My father is not a friend and a policeman. Only. More upon in the during the trial court or the inquiry as well as the before this court, despite the completion of service, respondent number 6 never participated.
Please repeat again.
Respondent number 6, the person concerned picked up my father, my lord. Despite completion of service in 2019, in fact, my lord, he is not here. When this honorable court is directed, where is little address to place before this court, then one annexure they have enclosed, he was transferred to Sikkim, my lord. Despite his availability method, when he get the notice from this honorable court, then he was transferred to Sikkim High Court. It is very much clear, my lord. I have in their affidavit, they have enclosed that order, my lord. So his conduct also shows, my lord, is this.
What is there with this conduct? If he is transferred by the authorities, how do you accuse this conduct?
During pendency of the matter, my lord, he was very much available here, my lord. When they received notice from this honorable court, he was transferred, my lord. That is clear, my lord.
That is his conduct. Very good. New thing we have learned. Thank you. See, one unnecessary word you use, you destroy your own credibility. Can't we rely on so much on the learned counsel, but one or two extra sentence,
Yes.
words, you destroy your own credibility. You can accuse the government of malafide transfer, but how can you accuse a person who is transferred to question his conduct? Today I have made this statement to you, and tomorrow I am transferred from this court to another court. Will you say that the conduct of the honorable judge was mischievous? And please come to this additional affidavit, page 110.
And I think, yes, my lord.
So this inquiry report, what happened?
My lord. It will report on the- Yes. Sorry.
Lordship has indicated the inquiry report of this learned CJM. Yeah?
Pardon me?
Lordship has indicated the inquiry report of the learned CJM.
Yes,
Yes.
CGM gave it to the district judge.
Lordship.
After that, what happened? What is the next, what is the next action after this report was submitted?
Well,
Final report. Final report, please.
this was conducted under 176 PRPC. Yeah?
Yes.
In case of that.
So it goes. What the problem? What the problem?
Mr. Nath, what we are trying to understand is that, you see, this report was submitted to the chief, to the district and sessions judge.
My lord.
Now, the inquiry is under 176A.
Lordship.
Who orders this inquiry?
Well, the 176 provides that in case of that, when the report comes to the judicial magistrate, the CJM, then an inquiry is to be conducted under 176.
No, but somebody must order. As chief judicial magistrate will not so to start an inquiry. somebody must have triggered this inquiry or order with this, somebody must have triggered this inquiry. Some order or there's a way to take cognizance of an offense. It can be within the meaning of the PNS where it says that if crime occurs in the presence of in the knowledge of the magistrate, then he may cause an inquiry to be made. In this case, what had happened?
See, because that would come.
176 into NA code.
Please, independent. That
176 is a rep.
take the petition, Mr. Miller.
176. Let it logically takes up 176 of CRPC. One 176, not one. When any person dies while in custody, one 176 provides for inquiry by magistrate into cause of death. When any person dies while in custody of the police or when the case is of the nature referred to in clause 1 or clause 2 or subclause 3 of section 174, the nearest magistrate empowered to hold inquest shall, and in any other case mentioned in subsection 1 of section 174, any magistrate to empowered may hold an inquiry into the cause of death.
Please stop here. So here there is two things. Number one is that magistrate who's empowered to make an inquest.
No.
And second is any other case magistrates who are empowered. There are two magistrates who are empowered to make this inquiry. First, one who is the authority to conduct an inquest. Judicial magistrates do not have that power. Because traditionally what has happened, although the judiciary is independent, but the
Right.
judiciary is in the district is still under the magistracy of the district magistrate. For all of the purpose, appointment of APPs, appointment of PPs, and then conduct of this, even the steps, everything is to be done by the district magistrate. If you look at our criminal code rules and orders, you'll find, even in the high court rules, you'll find that the steps are required to be taken to the DM. So that is one part.
No.
Therefore, either it's a magistrate who's empowered for inquest, or number two, magistrate who's empowered to do that inquiry. So therefore, there must be something which triggers.
That's I am referring so because
Because even if this report goes to the district magistrate, district judge, but without a committal order, can a district judge take cognizance of the offense? No.
no.
So therefore, transmission of the report to a district judge or a sessions judge.
Gotcha. But
Because ideally, these reports are sent to the government
Got it.
because it is the duty of the state to prosecute. So normally this is required to be sent to the uh,
176.5, there is an indication.
hmm?
176.5.
Yes,
The judicial magistrate or the metropolitan magistrate or executive magistrate or police officer holding an inquiry or investigation as the case
that
may
is
be.
to send to body to the qualified medical.
No.
This is anything more.
Or author qualified counsel. Yes, my lord, when the information from police comes, let.
Where is the where is the order of that re-inquiry by the Chief Judicial Magistrate rejecting the FR? Which page is that?
Yes, my lord. My lord, 167, 167,
167, that first one.
yes. It is 12/7/2013. If you go to the phone, then you put it up to the phone. You get done.
Mr. Teka,
my lord.
if I remember it correctly, after the reinvestigation was ordered,
My lord.
that particular PS case
Yes,
was registered and a GR case was also registered.
yes,
In the GR case, again, an FR was given,
yes, that is also.
exonerating.
Yes.
And then you filed an RJ petition and thereafter on this, a complaint was registered,
Oh, yes.
right? Now this, last time you were saying that you were in the process of filing the complaint.
Yes, my lord.
Has it been filed or not been filed?
By as the information received from my learned friend, my lord, not yet filed, my lord. These are this. My can I confirm? But what it's photo of the one not used. I'll prove it. Good. Let a complaint case be registered on the basis of objection petition. আমার পাশে Next. Milord, can I show page 169, Milord, the last order passed by the last paragraph, Milord. Page 169, Milord. Yes, Milord. In the same annexure C, Milord. After filing of our objection petition, Milord, the effort submitted I was not accepted. Let a complaint case be registered on the basis of the objection petition, which shall be filed on the next day.
Have you given us the copies of the those judgments?
Milord, yes, Milord, I'm fine. Milord, before taking to the citation, I'd like to show one thing Milord, from record, Milord, where there is, prior to the incident, even 6, 7, and on even date of arrest, Milord, there is no entry so far as my father's arrest is concerned, the record, Milord. That record I'd like to draw your lordship benefit.
Mr. Dekha, we have been hearing this matter for 3 or 4 days.
My lord,
Now that point that the respondent number 6 has been transferred to Sikkim, that was never brought to a notice. Because you see, unless we direct a notice to be served on respondent number 6, we possibly can't pass any order in his absence. Because this is a writ petition, it will be bad for non-joinder of necessary parties.
your lord,
Why did you, if you are knowing that, why did you not address us and had the notice sent at the correct address?
and correct address they have provided, they have enclosed with orders there, my lord.
We understand, but you'll have to tell us. You don't expect us to read every day 500 pages. You see, for last 10 years, this case was not proceeding.
My lord.
Only when this bench took up the matter on the regular basis, then that's why now we have come to a situation where we have started hearing the matter.
My lord.
And all these 5 dates, when we have heard the matter has gone down the drain, just because the respondent number 6 is not a party, notice has not been served. Today we are also spending time, 40 minutes of time, and we are at the same place. We are unable to dispose of the matter. And there's also no point for further hearing because we are not, we are uncertain about the constitution of the bench. We can't keep it parted. You are aware of these things. We are constantly telling you in this court that these 2 weeks are difficult for us. But this is a case, it doesn't take time to dispose it of. We could have done it. With the experience my esteemed brother has, he has given an idea, we could have implemented that, but now we see that respondent number 6.
But-
It is not served.
So if I'm permitted to submit. Look, here logic has, if logic finally considers it clear.
No, even if you see, the issue is not that.
Sure.
Still, there are materials by virtue of which we can pass orders.
Malab, there are materials, but my respectful submission is that investigations are done and materials are there, malab, they are relying on statement of 2 witnesses. Those 2 witnesses were examined by the learned CJM in the report. Logic may permit me to read the report, malab. And logic has, the doctors were also examined. Doctors had, malab, found no injury, malab. The nature, the manner in which the statements have been given by 2 witnesses.
You see, you please see the sequence. Number 1, somebody is being arrested and taken to the police. Once you take custody, there is no denial that section 50 has to be complied with.
Yes, ma'am.
You don't, the police officers don't make a GD entry. Therefore, they stay in the police station itself. We accept what Mr. Deka is saying. Let us assume for the time being his statement is correct and the GD entry was not made. What made you allow a person to be inside the police station? And then when he dies, the report is handcuffed. We have already explained the meaning of handcuff to you.
Logic.
How will it happen? Handcuff is just, no way that it can happen, except for use of force.
Malab,
And in this, there are 2 things. That's why we asked this question. We were pondering about that question. How this inquiry happened.
in the affidavit, they said that the wife of the petitioner has filed an application before the CJM for an inquiry under
But that
176(1)(a).
That doesn't permit an inquiry. A CGM cannot assume jurisdiction.
Under section 176(1)(a).
We understand, but it still be assuming jurisdiction.
Logic, in this case, my lord will see malab, whether this is the case for reinvestigation by CBI. That is their prayer. And the compensation part.
You see, in this, a petition of this sort, we are not bound by we just have to give you a sufficient notice and then proceed with the matter. In matters like this, we are not bound by procedural law.
And vis-a-vis malab, their complaint, Naraji petition complaint has been directed to the register. That is also
That is one part.
that is one part.
That is one part.
So simultaneously, whether the investigation by an independent agency that comes
So
on.
we'll see when we hear the matter. Actually, the problem is that in the absence of a responsibility, we are finding it very difficult to pass any orders. It may go adverse to we don't know what order will pass, but still if any order adverse to respondent number 6 is passed, it'll be without hearing him. That is the difficulty.
Lordship has passed an order on 14/9/2023, and in response to that, my lord, we have filed an affidavit giving the address of the respondent number 6.
I understand, but every time you don't expect us to read it and then
No,
find out
Lordship,
whether it's a
Lordship,
necessary
no,
party or
that-
not. We are not reading this
True, my lord.
for the
It is
purpose of ascertaining who's a necessary party.
true, my lord. True, my lord.
Without proceeding against him, we can't do it. Where is that affidavit page?
Well,
The address is disposed where?
My affidavit, Lordship will find at page number 85, my lord.
85.
80, Lordship, 87 it starts.
No, 87 is a postmortem.
Well, I think there is some difficulty in the translation. Kindly take the affidavit filed in the month of January 24, my lord. It is an additional affidavit by respondent number 2, my lord.
January 24.
January 24. Nitul Gogoi is the deponent.
Okay. January 24 is 11 January 24 by Nitul Gogoi.
Nitul Gogoi, my lord. Yes, that is
Yes,
there, sir.
that is at page 154 in our brief.
I'm sorry, my lord. I 154, my lord. Got it. Paragraph number 3, my lord. I have also annexed the order at page number at annexure 1, my lord. And the address at page number 3.
You don't know. Look at this. In the website of your Assam Police, this person is in police headquarters.
As on today.
I don't know. This information given by net. I can't take responsibility of that. It's a compulsive bad habit.
I'll definitely verify, but because this was filed in the month of January 24, he was on central deputation.
No, we don't know, but today we need
No.
the correct
No,
address.
no, that's true, that's true. I'll take the information. It take few minutes. maybe.
Huh.
That's true.
Get it because we'll have to impede them.
Yes, yes, because he's already a party here. He's already a
No.
party.
Notice has to be served in a proper manner.
Yes,
in
yes,
a
sir.
proper address.
Malab, if he was on central deputation, and we filed the affidavit, I'll just take the information. yeah. His by name respondent number 6. I'll take the information, right? Logic, logic. I'll come back in after few minutes.
Yes, my lord.
Logic.
Supplementary item 9 for admission.
May I please? Go shop. The student leaders, please come forward. Please come forward. Yes, come forward, come here. I have something to tell you. The last matter we were hearing, there was a police inquiry, inquiry by the magistrate under 176, 1 capital A of the CRPC. To do a research and tell us on that. How is it, how an inquiry is made, what triggers it, and what happens to the report? You do a lot of research on that. Tell us. Yes. If you want, you can take that report, take this from here. The report is at page. I forgot, we'll mark it for you. In the, yes,
But may I please, your lordship, passed an order on 25/6/2025, directing the SP to conduct an inquiry regarding identity of the petition, whether possibly and the petitioner is same person on 25/6.
okay. Ms. Verma, you see this order? Issue of identity is good.
Lordship, I'll have to ask Mr. Pang if the report is there, Lordship.
Okay.
That will,
After some time. After some time.
after some time, we will be back.
It's okay. You want to see the record? Let's see this, because you need that order.
Item 2 for order.
May, may I please, your lordship? My lord, in fact, in this case, my lord, today only I have filed my wakalat nama, my lord. Name is not there, but then nature of habeas corpus petition, my lord. Because my wife is in custody of my in-laws, my lord. That is the case, my lord. Though I approached the police, my lord, and police in fact handed over my wife to the, my lord, my parents, my lord. Now she is in custody since December 2024, my lord.
No, because you must have been briefed in the meantime. What had happened was
My lord,
you claim yourself to be the husband,
my lord, I have, my lord,
Correct.
in my petition.
and then it says that you are married in according to Islamic rituals.
My lord,
That is a question whether where is the proof of a marriage? Because you see, a third party coming to the court and saying that I am the father or I am the brother. We can't just ask the police to get the girl and hand over to this custody. We have to be satisfied.
that is correct, my lord.
So,
But
How-
the,
how that there was a marriage?
from what has happened, my lord, from my learned friend and the other sources, my lord, which we have collected, my lord, is that there is no, we could not get any time to make the marriage register, my lord, before the Qazi. Or but the, my lord, the religious rituals, my lord, that the, my lordship well knows, my lord, that the proposal and acceptance in presence of witnesses, my lord, was there. In fact, my lord, one
it
thing
can't
is there,
happen.
my lord.
This can't happen because the girl was not of Mohammedan religion.
I know, my lord, I know, my lord, but before that, my lord, that the religious part of conversion was, my lord, was there. Without that, my lord, it will not be a valid marriage.
There's no evidence to that effect.
That is the difficulty, but the process was so fast, my lord. My lord, my lord, even I have inquired the petitioner also, my lord, and it was a very deep rooted relation between them, my lord.
No, that's okay.
My lord.
We are not, for once,
But,
even to
but for my lord,
Mr.
lordship
Mutaki, we have not
satisfaction,
questioned that relationship.
but for my lordship satisfaction, my lord, we are required to produce those documents, my lord, that is admitted, my lord. Without the document, we even cannot satisfy my lord that we married or something like that. Lord, even from my very limited knowledge, my lord, if I respectfully beg to submit, my lord, even if we assume, my lord, that the marriage is not a valid one, but even then, my lord, the live-in relationship and my lordship is well aware nowadays the boyfriend, girlfriend and living relationship are also being, my lord, has been validated by the Honorable Apex Court, my lord. They both are measures, my lord, without the consent courts, the work courts. So, my lord, here is a case, my lord, if we keeping the marital part on the other side, my lord, because that is, my lord, it will be very difficult to satisfy my lord without the documents, my lord, that the marriage and that apart, my lord, as the both religions are different, my lord, it will be very difficult. My lord, may I humbly pray, my lord, that as the girl is in custody, my lord, from December 2024, my lord, can her statement be recorded by a magistrate, my lord? If my lordship satisfied, my lord, because we have got the information we are getting, my lord, something untoward may happen to my, my lord, that girl, my lord, that then everything will go in vain, my lord. No, no. Purpose to continue.
Not without prejudice to anything, we may directly member secretary, district legal services authority to make an inquiry about the well-being of the girl.
That's true. On the other day, my lord, I have also submitted that. She will immediately go today or tomorrow and see the condition of the car. That I cannot operate. I have no,
This is district Darang.
this is
Uh,
Sipazar. Dorong.
Dorong district, Milo.
She is presently residing in the Dorang district.
Yes.
Dorong district at her own home, Milo. Madhuram Boro is the father of the Milo.
Jayantipur.
Kindly come
Mile.
to page number 23. This is his address,
Jayantipur, post office Burha,
Milo.
ये सिपाजार.
Sipazar.
Milo. Mhm. Well-being officer conducted report of.
Mr. A.R. Bhuyal and counsel. For the petitioner, he submits that he has filed his Vakaratama, which is not on the. Also heard. Mr. D. Nath, the senior government advocate appearing for respondent numbers 1 to 5. None appears on call for respondent number 4. Number 1 to 4, and this is 5. Next.
Oh, office file is complete. Okay.
Keeping open the query of the court as raised, as recorded by the order dated 23/7/2025. The court is inclined to direct the learned member secretary of District Legal Services Authority, Darang, Mangalore, to visit the house of Madhu, MADHU, next word Ram, third word Boro, PURO, of village Jayantipur, PO, Burha, PURHA, and the Sipazar police station in the district of Darang. To inquire about the well-being of Miss Mili, MILI, Boro, PURO, daughter of Madhuram, Sri Madhuram Boro. as it is alleged in this petition that
Yeah.
he was maintaining a live-in relationship with the petitioner, namely Intajul, Entajul Ali, son of Ruhulla, Ruhulla Ali, resident of village and TO, HELDHA, and the Bayata Study Police Station in the district of Abu. Next. The said report shall be sent in a sealed cover within a period of within a period of 15 days from the date of receipt of a copy of the order. And put in a seal cover. Let's make clear that at the discretion of the court, the said report may or may not be made a part of the record. And in any event, the said report shall not be constituted as an evidence. This order is without prejudice to the for the orders that we passed by the court. Next, this one. The registry, shall transmit a downloaded copy of this order by email to the learning member, secretary, Secretarial Services of Order, the run order. Next, this order shall be brought to the notice of the AOJ Civil Rule readable section. Next paragraph is from due fixed date after 20 days. 20 days. Eighteen eight fifty.
Lord, that report may be placed before my lord.
It will come, don't worry.
Mild. Mild,
Let the report be the seal cover for the perusal of the honorable court,
mild.
because the prayer of the petitioner is that it's a habeas corpus petition. Lordship will consider. If
You have heard the order.
I
Yes,
have,
sir.
I have.
Oblige me. Good work.
All right.
And have you got in the meanwhile that instructions?
I'm just trying. I'm trying. Give me 10 minutes time.
It's okay.
Item 9,
Pardon me.
item 9, Lordship, we would need some more time. Instructions are waited. Supply item 9, Lordship.
Item 9.
Yes, Lordship.
Okay.
Aha, 9.
How much time? Because we, on the last occasion, we gave liberty to the petitioner to pay for an adjournment. So how much time you need for the instructions?
Lordship, a week's time.
A
We'll
week?
send a reminder again today, Lordship.
Just tell us the date. You have a calendar.
Yes,
Is there?
Lordship. Date
Just tell us date.
29. 8th of August, Lordship.
Hmm?
8th of August,
The 8th of August.
yes, Lord. Or 7th.
Both sides are represented. Pursuant to order dated 25/6/2025. Ms. A. Verma, learned standing counsel for the FT matters, has prayed for some more time to obtain instructions and to address the court. So, next, accordingly, the matter stands adjourned today. Next paragraph. Right. Paragraph 8 of the order dated 25/6/2025. The court had allowed the petitioner, namely, Savera, SAPERA, become BGAN, make a prayer for adjournment. Before the learned member from a foreigners tribunal, Court, Kamru Metro Guwahati, in the proceedings of FT was space then TVK case number 7 of the 2024. And provided that on such petition for adjournment in filed, the learned tribunal shall adjourn the matter. Fix the same after 23/7/2025. Next, in view of the adjournment, wanted to pay. The said learned tribunal, receipt of petition for adjournment is requested to adjourn the proceedings and fix the matter after eleven eight 2025. No, not 11, make it 13. 13/8/2025. Next, petitioner is described. So this is certificate copy of the order before said when I quote, the said when I trial.
Next, it is 15.
Okay, back to you.
Okay.
Next, list on 8/8/2025.
God bless you.
To pay for adjournment,
Who moves the
Item 3 for hearing.
maybe resolution. Okay, 73, the opinion matter. Climate tribunal basically held that matter, link between the petitioner and his father was not proved.
just a moment.
Anyone keep that one? Check out the- Lordship, can we have this matter next week, Lordship? Copy it, current.
Yes.
Lordship, the brief I have is of a different district, but the name is same. He's from Dhubri and I'm carrying the brief of Nagaon.
Oh,
So my documents were not matching with him, so Lordship will take it up next week, Lordship, just a small adjournment.
because this adjournment is, today is very difficult.
I
Actually, this is-
understand, Lordship, 17 matter.
Okay. What says that represented? You are not understanding also, they have to matters with inadvertent, yeah, correct. Record is available with her. Next, according to matter stand that on date. Just after 2 weeks on date to get it ready. Taste. Oh, published.
Lordship has fixed a date
We are not fixing it, this 2 weeks again, you know, but,
after 2 weeks.
but have you taken bail? Yes. Yes.
With a hot copy.
Item 4 for hearing.
Lordship, 10 days time may be given. 10 days time may be given.
I don't get it, please repeat again.
10 days time may be given, Lordship.
10 days time, no. Not fair. Tuesdays and Thursday, we are finding it very difficult. That job. We're fixing very less cases. Let us start the hearing, then we'll see.
Lordship, we'll try additional affidavit. We'll try additional affidavit.
No, additional affidavit is not permitted. What do you bring on record? What do you intend to bring on record? You have to tell us, because the additional affidavit is not for asking.
Lordship, impugn order page 29.
Page 29. Just a moment.
Not- Lordship, in 1966,
Yes.
Lordship, in 1966, father of the petitioner name appeared in the voter list of 1966 as Hiles Topesor, page 35.
Other is
Petitioner father name appear, page 35. But in the said voter list, petitioner father name wrongly recorded as Muslim Sheikh instead of Muslim Uddin.
The petitioner is Hashim Ali.
Hasim Ali, Lordship. In 1966, petitioner father name appeared.
Where is your written statement?
Page 13.
13.
13.
What is the name of the father?
Father Muslim Uddin. And grandfather Ilahi Box.
And voter is that page?
Lordship.
1966 voter list is that page.
Page 35. In 1970, petitioner father name appeared. Page 37.
This is voter list of 66 is exhibit number.
Exhibit number 6.
Pardon me. Exhibit number
6.
6. Then voter list of 19.
1970. At village Tapeswar. Page 37. But in the same voter list, Lordship petitioner father name wrongly recorded Muslim Sheikh instead of Muslim Uddin. Lordship 1985, petitioner name recorded along with his father.
Just a moment. This is exhibit number 1970 voter list is exhibit number
7.
yes.
In 1985, petitioner name appeared along with his father. Page 40.
Yes.
In 1989,
This is exhibit number
exhibit number 12.
12.
12. Voter list 1985.
Yes.
1989, petitioner name appeared. Page 45. at village Tapeswar. Lordship, petitioner annexed Jamabandi copy in the year of 1966 at village Tapeswar.
This 89 voter list is exhibit number
13.
yes.
So again, Jamabandi copy. Petitioner annexed Jamabandi copy in the year of 1966 at village Tapeswar. In the said Jamabandi petitioner father name was mutated at legal heir, and the same land again mutated in the name of the petitioner after death of his father. Page 46. Lordship, in the year of
No, this Jamabandi entry, Jamabandi is exhibit number
11.
what is relevant in this, what is the relevant entry in this Jamabandi?
Lordship, page 24, Hasem Ali.
Age,
Para 24, page 46.
serial 24.
Serial 24. Serial 1, Ilahi Bak's grandfather. 24, Hasem Ali. And serial 3, Sri Muslim, father of the petitioner.
Serial number 3.
3.
Yes.
In the 1995, petitioner shifted village Piknapara from Tapeswar. And 1997, petitioner name appeared in the voter list of Piknapara, along with his wife, page 53. Page 53. In 2011, petitioner name appeared at the village of Piknapara.
Please repeat again. What did you say?
2011, petitioner name appeared in the voter list at village Piknapara. Page 54.
Fifty-four.
54.
Yes.
Lordship, again, page 56, petitioner annex Gowra certificate.
Page?
Page 56. Goft Gowra of Tapesar issued certificate in favor of the petitioner. Page 56.
Yes. That's same on report. Lordship exhibits. Lordship exhibit 7, 8, and 9. And 10. I could not annex here, but same on record. What are those exhibits?
7, 8, 9, and 10.
What are those exhibits?
Exhibits 7. Voter list 1970. Yes. Cell date. Exhibit 8, Lordship. Cell date. 1971. Exhibit 9, cell date 1980. And again cell date.
Just a moment.
No.
Exhibit 7 you said is voter list of 1970.
1970.
Then exhibit 8 is sale deed.
Cell date.
Of
The cell date 1971.
Yeah, then exhibit 9,
Exhibit 9, stale date 1980.
then exhibit 10,
Exhibit 10, stale date 2004.
we take a short break and come back.
Your Lordship, Annexer 1, 2, Lordship, judgment page 30, Annexer 1, 2, and 3.
Page
Page 30,
31, 3,
30,
30.
30. Annexer 1, Annexer 2, and Annexer 3, I could not annex, Lordship, but same on record. And exhibit 1, and exhibit 1, 2, 3, 4, and 5. Those are other records.
You see, there is one difficulty which disconnects you everywhere. That is the spelling of your father and grandfather. Now, what you have done is come to page 5. No, sorry, page 6. Your rate petition, page 6. Have it? Please read that paragraph. Please read that paragraph. You will understand what has happened. This paragraph.
Lordship, whose paragraph?
Read page 6, paragraph 14.
Okay. That after noticing the wrong name of the father of the petitioner in the voter list of 1966, 1970, and 1985, the father of the petitioner applied for correction of his name. In the meantime, the father of the petitioner was died and his name dropped from the electoral roll from the subsequent voter list. So the
Now you see, now this is your statement that you have introduced that your father applied for correction of his name.
No.
Now your father died. Therefore, this is a primary evidence to show that the person whose name, in whose name the voter list is, made an objection. But that you have not proved.
not voter list group, Lordship.
No, we understand. You see, what has happened is, let us say there is an error in my order, which I am passing today in your case. What will you do? You will either make a mention before the court, or you will file an application for correction of the order. Now, if you apply for correction of the order, it's a document. So if there is a document existing for that, nodal evidence cannot be acceptable. You got it? There you got trapped. We'll take it up tomorrow. Be prepared. We don't want to discourage young counsel on that account. Sir, Ahmed may not have got that opportunity. We give you that opportunity because once there is a documentary evidence and which you have referred to in your petition, and come to page 12. In page 12, this paragraph 14 is true to your knowledge.
Yes,
Now that means that if you have something which is true to your knowledge, and then you don't prove it, then our oral statement that there is a difference in your name of your father may not be an acceptable proposition. So we give you time to address us on that day, tomorrow. And the second query to you is, in your written statement, you have said many things, but it doesn't connect you anywhere. Any paragraph, you read any paragraph. For example, come to paragraph 8, you say the government of Assam is due to pay annual patta.
Annual patta,
But why is this statement made? You have not said anything. How does it connect you? You have not said anything. Then in your written statement, please come to paragraph 26. Here, you have referred to the discrepancy in the names and you have referred to an affidavit. But it's a self-serving affidavit. There are many judgments to that effect. But again, this relates back to your paragraph 14. If you have knowledge of applying for correction, have you not proved it? Because you see, that your father, what is your father's name is best known to your father. He applied for correction. And it is true to your knowledge. That means you know. Speak tomorrow. Also is represented. Miss
A. Hussain.
A. Hussain.
My name is not there in Okalatama. I am appearing on behalf of
Miss
J.
A. Hussain, hearing on behalf of Mr. J. Ahmed, and counsel for the petitioner. Was heard for some time. However, on a query of the court, comma, made in connection with statement made in paragraph 14 of the writ petition. Wherein the petitioner stated that his father had applied for correction of name in the voters list. Or the joint counsel of the people placed for the client to address the court. Next list. Again on. Pick it tomorrow. Zero. Yes, sir, not, you got information.
Well, I have verified. He is here.
He's here.
Here. He is presently serving as DIG MPC.
DIG,
DIG MPC. MPC. Modernization Planning and
MP,
MPC.
MPG,
C. Malab.
C.
C. And he joined on 1/6/2024.
No, whatever we, I
Lot-
just have,
lot-
I'd have it.
Logic.
What says a representative? Next, query of the court, Mr. Dinar, senior government advocate. Upon receiving instructions, submitted that the respondent number 6 is presently posted in the office of the Director General of Police, as Deputy Inspector General of Police, within bracket,
MPC.
MEC. Next, pardon. The learned counsel for the petitioner shall bring on record the correct postal address of respondent number 6 by submitting specially typed out post title and handing it over to the AOJ civil pending section for being incorporated with it with suitable amendment to the central registry. Thereafter, the matter is respect to the before the court for enabling the court to pass an order for issues of notice of respondent number 6 at his correct postal address. Correction shall be done within 2 days. The matter be immediately listed thereafter.
Need to question.
Follow. Mr. Leka, give this to us on the next day.
Item 6 for hearing.
May I pray that matter may be taken on some other thing.
On these Tuesdays and Thursdays, we are listing very less matters.
Well, that's not very good. Next week, my lord.
So is it they made by mistake?
Tuesday. My lord, it is fixed on. It is fixed on
We're fixing it after 2 weeks. We don't have a,
after 2 weeks.
because there's some difficulty in this.
My lord, interim order may continue. Interim order may continue.
Is it a limited order? No, normally that order. we don't
Interim
have.
order is there, man.
Was
Your
it-
lordship would be pleased to see 13/3/19 order. तो भूल के लगा हुआ। मतलब first order was of 3/12/2019. Thereafter it is continued.
But then you'll have to apply for, you'll have to file an IA. Look at this order.
मतलब break of continuation. I will file my. For
Look at
continue.
the order, you will understand. The matter was adjourned for 2 weeks. The rule was issued returnable in 2 weeks. And the interim order was only for 1 week.
Oh,
33, which you are referring to. No, 33. 33, which you are referring to.
13/3, madam.
Matter was adjourned for 2 weeks, but the interim order is only for 1 week.
Until next week.
It was supposed to be listed after 2 weeks, but interim order is only for 1 week. You have to apply for an IA.
I will file. To February. Obligation.
Item 7,
May please, your lordship. This review petition has been filed against the order dated 4/12/2018, passed in petition 4876/2018. Annexure 18 is the order. Page 71.
Yes.
My lord. Lordship, we kindly have to look at the relevant portion. Page 74, my lord, reflected the documents which was relied upon at the time of trial.
exhibit one is the ACLC admit card of the petitioner. He appeared in the ACLC examination. The admit card was exhibited. Then annexer two, exhibit two, NRC of 1951. Containing the name of Kutu Sheikh appears as son of Satullah Sheikh. Kutu Sheikh is the father of the
You see, we'll tell, we'll, okay, query.
my lord.
The two grounds on which you are praying for review is number
Right.
one, that there is the evidence was disbelieved because of spelling errors.
My lord.
Correct, discrepancy in the names. That is one.
Discrepancy, minor discrepancy, he is,
Whatever be, but that is your ground.
my lord.
Second ground, the substantive ground of this is that for the fault of the lawyer, you should not suffer.
My lord.
These are the two primary grounds. in fact.
Grounds, my lord. And my lord, exhibit one,
In
the,
fact, this order of the court is of 4/12/2018. And for review of the order, you are now relying on a judgment which is Sirajul Haq, which is reported in 2019. That means a subsequent judgment. But we have n numbers of judgment which says that subsequent judgment will not be a ground to review the earlier order. That's one. The second ground which you have taken about the mistake of your counsel. In that connection, we don't find anything that you have raised the objection with regard to the performance of your learned counsel.
my lord,
whether it
my
is a
lord,
mistake or
I
not.
am I am a person having no, my lord, no knowledge about the legal proceeding.
So we understand,
And-
but you see, the problem is that in the absence of a lawyer,
If lordship
even you may
ask
not
me,
like
then
us
we
to.
will implead him, my lord.
No,
we'll
no,
implead
question
him.
of impleading will not come. Because this may be a litigation, we don't know, we are not accusing you, but this may be a litigation which is a, what you call, what is it called?
ये हमारे एक हजार में ना
I had forgotten the
No,
word,
by
it's
the-
collusive,
my lord.
it's a collusive, we are not accusing you, but it may be a case where impleading may make this writ petition a collusive litigation. Why, I'll tell you. A will come and say that, yes, I have done a mistake. He has been
That is
paid-
apparent on record.
No, no. You see, it's not your original case.
Mistake, my lord, what type of mistake, my lord? He has not mentioned the mother's name in the WS. And that has been picked up, my lord. Mother's name is available in the documents, my lord. The admit card which is exhibited in exhibit one, where parents' name is there.
But till now, you have not raised any objection.
That's a minor mistake has been,
No, no, it's not a mistake. We see, once you say it is a mistake, that means we are accusing the lawyer of a misconduct. We can't do that. Please understand our
my
limitations.
lord, misconduct, I am not making allegation, but lack of his also, lack of knowledge. The advocate is also not of that level, my lord. So that was knowingly or unknowingly he has committed mistake. That I am not making it that he's it is willfully or any negligent manner or to cause harm to the petitioner. He has done it. He's done it maybe unknowingly, my lord.
No, you see, for that, the first requirement is that you will say that I have instructed the counsel to mention the name of my mother. He did not do. That allegation is also not here.
No, therefore, my lord, the allegation, my lord, our stand is that he has committed mistake, maybe unknowingly, my lord. But the court is to decide for the ends of justice. The documents which reveals the parent's name, that documents has been rejected, saying that the mother's name is not mentioned in the WS. And my lord, exhibit one, is it required to prove it by comparing the primary documents? Is an admit card, it's a public documents, my lord. That has been rejected, saying that primary documents not produced.
But then this will make our judgment erroneous judgment. We can't review that.
My lord,
If we have failed
my
to
lord,
consider
the
that,
citizenship, my lord, this way is carteling, my lord. This way is carteling his
no,
parents' name is in the voter list of 1966. And admit card goes to show the linkage of the petition of the parents. This is sufficient. If everything, my lord, is picked up, my lord, then nobody will able to prove the citizenship, and that will my lord, connect to the allegation of the politician. Politician are saying that 1 crore foreigners in Assam.
we don't
The
know.
politician are saying like that.
You see,
So the finding and the
And-
appreciation goes to that level, my lord.
we understand it would have been a great political statement, but the problem is that in the court, we are confined ourselves only to the litigation which we are holding, which you
My
have pleaded.
Yes, my lord.
Can we travel beyond that?
My lord.
And would you like it in
My-
your case, we travel beyond pleadings and then make any
My-
observation? Even you will not like it.
My lord.
So we have our own limitations.
My lord, the court is to, my lord, see, my lord, for the ends of justice. My lord, some statement not available in the WS, therefore, the documents can be discarded and primary requirement of primary document to prove the admit card. My lord, is a primary public documents, my lord. Simply not free from doubt. It's not free from doubt. With that finding, can it be rejected, my lord?
Mr.
Citizenship case.
Mr. Sikdar, we are in review jurisdiction. We are bound by the parameters of law. And
My
the
lord,
parameters of law.
My lord,
is-
many judgment has been passed based on narrative, my lord. Based on narrative, not on law.
Which is that ground? Which is that ground in your writ petition?
My
This
lord,
is-
ground is, my lord, first ground is, my lord, the exhibit 1, the admit card has been rejected. Not being produced the primary document, and also holding that it is not free from doubt.
In our judgment, how we have examined that in the impugned order of this court, how we have examined that.
My lord. Page 75, the order of this order in the writ petition, my lord. Page 25, paragraph, fourth paragraph, Mr. D.P. Solia, learned counsel for the petitioner, by relying on exhibit 1, submits that exhibit 1, which is SLC admit card, clearly in mention the petitioner is the son of Muhammad Udu Sheikh and Amina Bibi. The said certificate issued by controller of examination, Sheba, having been produced in original, the original was produced, and exhibited exhibit 1 is the primary document under the Evidence Act, which need not be further proved, and the same ought to have been accepted in evidence by the learned tribunal. The said document having clearly reflected the petitioner is the son of Muhammad Udu Sheikh and Amina Bibi, it must be held that the petitioner has been able to establish linkage with his projected father, namely Udu Sheikh. On the other hand, so-and-so learned senior special counsel, standing counsel, foreigners tribunal submit that on the basis of exhibit 1, which is only an admit card of SLC, it cannot be said that the petitioner is the son of Muhammad Udu Sheikh. He further stated that there is no mention Aminawi in any exhibited voter list. Therefore, it is submitted that exhibit 1, by which petitioner seeks established linkage with projected father, is not free from doubt and accordingly cannot be relied acted upon. My lord, my lord, the trial court, other documents are not produced, but before the my lord, writ petition, we have produced the other voter list, which goes to show that his name with his parent. Lordship may kindly have a look at annexer page 69, the voter list of 2014.
59,
My lord, page 69.
69.
2014. Udu Sheikh is in the top, and petitioner's name is at serial number 413 Aminul Ali Udu Sheikh. name is with parents, with father, my lord. So, my lord, my humble submission is that review can be considered on production of new documents. The learned division bench rejecting writ petition have not considered it, but it is a fit case to consider on this documents. I am not falsely claiming. I am producing the voter list of 1966. My lord, the cross-examination part of the petitioner witness is very important, my lord. there is no rebuttal evidence to my claim. If we go by the full bench decision, my lord, paragraph 117.3, 112.1, my lord. This, my lord, full
Which
bench
judgment?
judgment of the Muslim versus
Muslim
Muslim
Mandal.
Mandal, my lord.
Paragraphs?
Paragraph 117.3 and paragraph 117.4.
Yes.
My lord,
This is on what point?
my lord, on the point that whatever claim has been made by the petitioner proceeding based on some evidence, if it is not rebutted, if there is no rebutted evidence, then declaration is illegal.
Yes.
May I read, my lord?
It's okay. We have read it many times. I
My-
just tend to forget.
My lord, then 117.3 and 117.4. Also, my lord, 122.1. In absence of rebuttal evidence, due cannot be taken otherwise, my lord. So, my lord, I claim, my lord, proceeding claim that I have completed my SLC examination and passed the same in the year 2008. I voted for the first time in 2016. I have been voting since 2012. I have not submitted any voter list showing myself as a voter, but only submitted voter ID card. The name of my father is Kudu Sheikh. The name of my grandfather is Amatullah Sheikh. I have submitted the voter list from 1966 till today, showing my family member as voters. There is only one exhibit 3, the voter list of 1966 of my father, but no other voter list. So my father is voter in 1966. Also produce some land documents showing the name of father. Everything is discarded. There is no discussion, my lord, regarding the exhibit 8. Exhibit 8,
8.
my lord. It is at page 54 vernacular, translated at 53, my lord. No whisper at all about exhibit 8.
I think exhibit 8,
It's Kesapatta, my lord.
there's an observation by the High Court that exhibit 8 was not proved through by calling the officials. I think that is the observation.
My lord,
Right, no?
in the judgment, my lord,
If I'm not correct,
my lord,
something mentioned.
no discussion about exhibit it.
No, it is there.
In this judgment, nothing has been discussed. No reason has been assigned why, my lord, exhibit it cannot be considered.
Yes,
My lord,
in the opinion, it's at page
page 75.
paragraph 4. Last two lines of the paragraph 4 of the opinion. He has not examined the issuing authority of exhibit 8, that is Kachapata. In exhibit 8, there is no date of issue.
File file তোমালোকে চাব না ফাইলটা petition আছে কি হেৰি কৰি আছা My lord, whether patta may be kacha or pakka, my lord. Whether patta is required to be proved by calling issuing authority as a witness, my lord. In the light of the Mojibur Mia case, my lord. Patta, whatever, kacha or pakka, is issued by the authority.
For that, for
My-
this answer,
My lord,
instead of me saying it,
Hmm.
you'll have to visit the Assam Land and Revenue Regulation and then find out what is the evidentiary value of Kachapata. Kachapata, according to my understanding, nowadays the officials work on a, what you call, they do not follow the executive instructions. But normally, the manner in which we were trained is that a Kachapata was always written by pencil. And therefore, that was not permanent. There was a requirement that Kachapata is issued. After that, it goes to the Deputy Commissioner's office. Thereafter, if everything is correct, then a patta is issued, which is a final patta. So a kacha patta is only a kacha, and therefore it is only a secondary evidence. It can't be a primary evidence. That is how we were trained. We will be wrong.
my lord,
I'm not debating
maybe,
on
my
that.
lord, nothing may ignore that, that one. But my submission is that my father is voter in 1966. That voter list has been exhibited. And I was also cross-examined. I claim that my father is voter in 1966. And there is no rebuttal evidence. So in the light of the full bench decision, the judgment is not correct, opinion is not correct. And my humble submission is that at least, my lord, the voter list which 2014, which I have, although I have not produced in the trial, but it was produced before this honorable court. This may be taken as a document for review of the judgment, my lord. My name is with my father.
Mr. Sikdar, having said that, I presuming that you are that you have nothing more to add. Can I say something which may hurt you, but ultimately it boils down to the first submissions which you had made.
My lord.
Am I permitted to say something? that
My lord,
is-
yes, my lord. Yes, my lord, why not? My lord, may happen, my lord. My lord. My lord, I admit it, my lord. I admit my these things happen. My lord. My lord. My lord. My lord. My lord. My lord, although my lord, in review petition, I have not made the due process, but we have made in the argument, my lord.
Not to find fault. It is just trying to impress upon you that at times inadvertently mistakes do happen.
My lord.
But if every time we reopen a matter just because there is some error somewhere, foolproof, you can
Yes, my
make
lord.
something foolproof.
Yes, my lord.
But I am told by someone, his name is Robert Murdoch. He tells that one thing can be foolproof, but you can't make everything foolproof, damn foolproof.
Right.
I remember this because of a small story. boy gets an unbreakable thing, a toy. You give a child a toy which is unbreakable. First thing he will do is that he'll put a hammer and then try to break it.
Right.
So, child having less knowledge of preservation may break it, unbreakable thing. So this is just in a lighter note, not to find fault. We are not finding fault with it. We will not read it as adverse to you, but problem is that second time many people may find fault with.
Right.
Yes.
I have nothing to say. Only thing is that, my lord, the order of this honorable court, my lord, judgment of this honorable court, there is nothing error apparent on this judgment, my lord. What my learned senior friend has argued, my lord, this is the argument of the original writ petition, whatever argument is made. So in review, my lord, I don't think the original writ petition is argued, because all these things were considered by this honorable court, my lord, while in the earlier line of litigation. And this honorable court has ensured, my lord, clearly ensured, my lord, if mostly, more particularly with regard to the admit card. If my learned friend is, my lord, aggrieved with this opinion order, my lord, definitely they can approach the honorable apex court. But I don't think, my lord, in the review jurisdiction, the same thing may be reheard and it may be reviewed. That's my humble prayer, my lord. In fact, they have approached the honorable apex court also. My lord, they could have raised all this question before the honorable apex court, my lord. I'm not saying that they cannot raise. Definitely, there can be error in the judgment of this honorable court. And second thing, my lord, in the writ petition, my learned senior friend has argued, the writ petition, they have submitted some documents. And my lord, in certiorari jurisdiction, it is definitely, the court is not going to entertain because yesterday I had furnished my lord, judgment of the honorable apex court, my lord, what it is said, in certiorari jurisdiction, the high court cannot allow new documents. So if they want to file a review, then they will have to go back to the original tribunal where they can produce a new documents with a prayer that they, despite of due diligence, they could not file those documents, they may be allowed. Well, that's a different issue. But in the review jurisdiction, in the high court under certiorari, this honorable court has said, I can have judgment, numbers of judgment of this honorable court, but it is said that in the review jurisdiction in the high court, that is on order passed in certiorari jurisdiction, my lord, the high court is not going to entertain any new document. So that is the.
Well,
My humble prayer is that, my lord,
My lord, the
it is
petitioner
not a
has already
case for
approached-
review. It is not a case for review of this review, my lord. So review, because as your lordship know, it is a limited jurisdiction.
My lord, petitioner has already approached, once approached the Honorable Supreme Court, and Supreme Court has remanded to the Honorable Court. The order I have annexed, my lord, at page 78. Supreme Court has
They
observed
have
that
withdrawn the
if
petition,
the
my lord.
liberty is given to approach the Honorable Court in a review,
Page 78, it is, they have withdrawn the my lord, leave petition. It is their prerogative, my lord. They can definitely withdraw it. But
my lord,
why
with an
did it-
observation that the petitioner can.
Okay, we have seen that, this, what we have seen.
Yes. That liberty is always there, my lord. We have seen numbers, all the orders the honorable apex court allows to, my lord. If they want to come back to this honorable apex court, they will be, my lord.
We can't make a comment. One says the order of the Supreme Court, we have
Yes,
to respectfully look into it.
Yes, that's fine, madam. My submission is that, madam, if they can go for appeal before the honorable apex court, definitely they can. But I don't think it is a case for review, man, in any matter.
You say, yes, that are count for the petition, as well as all the comments are. Argument is concluded, judgment is reserved.
Item 8, my lord, what we can fix a date, my lord.
Leave.
Let it be on 19th or 21st of August, my lord. Easy is appearing, he's making a mention for a date, fixed date.
You want it when?
19th of August, my lord, or 21st of August.
Yes.
Okay.
होता है purchase the representative to the prosecutor and the matter not. Okay. Yes. List. Again on
19th of August.
19/8/20.
Okay.
19.
Then 21st one. 21st.
No, the
Same.
No.
Division bench, item 1 to 5.
Here. What is this? Party in the top. That is, state law. And so, now the state government is the effect. That's not. Yes, so. Fire. Yes. Oh. Number 6. This reflects only investigation and fact. The story here for the state.
So some confusion in my mind. In this case, the item number 1 is a death reference. So if there is already a trial and sentence of death, what does this mean that this is transferred for investigation and
Yes.
trial to Guwahati? What does it mean?
That is what I was asking of. And so, investigation and trial. Asking. But the collected info or inform. But now it is.
The prosecution will be by the state.
By the
Good for the respondent. Good for the respondent, because then the problem is that how do you suppose you will get well, then whatever is there on record, we'll hear on the basis of that. Okay. We take this on record. But for that, you'll have to put an initial and give it to us, because on based on that, we'll have to Excuse your appearance. But have you informed in writing to the state government? Has there been a communication? Because today, are you ready for the hearing?
Last only the type from our what are the all that the those all that is now what are that's otherwise I have not আমাদের তার স্পটিত মায়ের দাদার অর্থ বলতে ইনফর্ম লেট ফাইল করতে yes already attended about that
No, you see, whatever you do between the two governments, it's for you to decide who will do what. But we still don't have any clarity. You see, it's a anomalous situation. Prosecution by NIA and then appellate argument by state government who has not dealt with the investigation.
that part also discussed with my brother also.
I don't know, for us it will be wonderful. And there is another issue. This is a reference of 2018. This must be taken up on day-to-day basis now. If we take up the hearing, even if today we are adjourning, it will give you not more than 2 days. We propose to hear it on day-to-day basis.
I have some problem, my lord, because I was contact with the brother of the my lord petitioner. He told me that he will take the brief, but he has not taken the brief, my lord. Day before yesterday, I have
He has
given-
faith on you, Mr.
I
Chaudhary.
can do, my lord. I can do, my lord.
He has faith on you. Then why he'll take a brief? He's just threatening you.
I am willing to do this case, but they
Yes.
are going, they will go to. see
He's
Mr. Pre-
threatening you.
I'm willing to do, my lord. I'm ready.
Maybe, maybe during this period,
Yes, my lord.
by the time I'm here, you have hiked your fees too much.
No, no, my lord. Not a single piece I have taken.
What I feel family can because we have no right.
To clear like what
Where is
Nanda. নকলে নকৰি কিছুমান উকিল কিনা যায়
My lord, day to day.
So far as prayer for adjournment is concerned, what do you say?
I mean, because they are also confused, my lord, because of.
No, they are not confused. They know everything.
চিধা চিধি কথাটো কোৱা
When the government says,
My lord.
even the DSGI knows about it, Mr. He also knows about it. But the problem is only that they want some time to get instructions, Mr. Goi.
I thought the
Okay.
No, I mean, প্রমোরে ডেবিট করেছিলি তো কারণে নেগোসিয়েশন এটা কবে
But to all of you, since we last heard it on 4/10/2023, under the High Court rules, we can't keep it parted.
Yes, sir.
With the situation, the second is that since in normal course, I'm on a different roster. To keep it parted would mean that again we'll have to break the roster and then come in. So we say that not be treated as parted. Mr. R.K.D. Chaudhary, learned DSGI, as well as Mr. K. Gogoi, learned. Your status will be APP, public prosecutor for the state of Assam. Appear in death reference. Appear for the appear for the first part is called what? Reference. This is a reference made. What do you call in death reference? The first party is called what? For the state will say NIA. Appeal for NIA. In death reference 5 of 2018. Full stop. He submits, the learned DSGI submits that as per instructions, written instructions received by him, comma, the further prosecution of the matter is assigned to the government of Assam. Full stop. Mr. K. Gogoi, learned public prosecutor, submits that he has received the government letter. However, he is yet to receive the records so as to he is receiving the communication from the union government of transfer of the case. So, however, comma, he has not received any communication from the state government for prosecuting the matter. Okay, however, he has received telephonic instructions from the director of prosecution to the effect that the state would be taking up the further prosecution in the matter. Next para. Mr. NNB Chaudhary, learned counsel, appears for respondent number 2. For one who is there, no one.
We do that.
My lord, I'm at number 2, my lord.
So in item number 1, who is for 1?
Reference of the photo.
No.
Item number, we, in that reference, we are the respondent number 3.
You are 2.
Respondent. And he is the.
My earlier I appeared 4 also, my item number 4. My lord,
No, we are in item number 1 first. We complete one by one and then. In 1, who is for respondent number 1?
My lord, respond number 1, my lord.
No,
My lord, item number 4 is the Vishnu Narjari, my lord.
I am on item number 1 first.
My lord, that's why, but item number 4, I appeared, my lord. So brief has been taken from me. I also appeared in the item number 1 also, my lord. On behalf of Vishnu Narjari, my lord.
এইটো সোধা নাই এইটো কিমান হ'ব
Item number 4, it was my lord, I appeared. So brief has been taken from me. So my lord, in 1 also I appeared on behalf of Vishnu.
Then we record your presence because you have not been recused in this. There is no order to recusing you from the case. So we record your presence as number 1. Number 1 will be Mr. Mr. M. Saranya for respondent one, and then say Mr. NLB Chaudhary for respondent two are present. Next part. Accordingly, on the pair made by the learned public prosecutor from Assam, the matter is adjourned today. List the matter on, just give a cap. And then item number 2. 2, 3, 4, 5. No, sorry, it will be in item number 2, at the presence of Mr. M. Saranya, learned counsel for the appellant, as well as Mr. R.K.D. Chaudhary, learned DSGI for the National Investigation for the NIA, as well as Mr. K. Gogoi, learned APP, learned Public Prosecutor Assam. Next paragraph. List the matter on along with death reference 5 of 2018. Then item number 3, record the presence of Mr. NNB Chaudhary, then the petitioner, and for respondents same Mr. R.K.D. Chaudhary and Mr. Gogoi. Here also say list on along with death reference. Connect all the cases with death reference. Then in item number 3, there are 2 IAs. Fix it on the same day. As the corrected appeal has been adjourned, these matters are adjourned today, list on so and so. Then item number 4, record the presence of Mr. M. Saranya, counsel for the appellant, for the respondent same, Mr. R.K.D. Chaudhary and V.K. Gogoi, list along with so and so. Item number 5 is record the presence of Mr. B. Prasad. The respondent is the same. Connect all this with their preference. And in all these cases, before you write the last day, the list on so and so, you also say that this bench had heard the matter in part on 4/10/2023. Accordingly, as per High Court rules, the matter cannot be kept parted for so long. So accordingly, the registry shall not treat this matter as parted before this bench. Then response also, we'll just discuss and we'll give the dates. Because this some disruption of the benches in these few days. Give the dates a bit later.
Yes, my lord.
So Mr. Agarwal, your presence will be recorded where? In the death reference. As a mic is correct. Oh, I'm sorry. That's why since I did not record your name, this is in night death reference. Also heard, not also heard, say, Mr. K. Agarwal, I'm a senior counsel, assisted by Ms. P. New the current counsel. Appears as a mic is in the matter. Okay. After some time, we'll give the date. We'll, court counsel will consult and we'll give a date after some time.
Well.
Okay. But we have our own doubts. A prosecution cannot be assigned. Prosecution cannot be assigned. At least we don't know of any such situation where the prosecution has been assigned. Prosecution will only be the by the person who is authorized to investigate. But I don't know.
That is in appellate.
Hmm?
Appellate statement.
No, that's why since we don't know, you see, many things we don't know, that's why we are asking. As enlightened members of the bar, you'll have to assist us and tell us, because this is a situation I've never come across. Mr. Agarwal, you have any experience in that? This is the court because now we are on death reference.
Supreme Court.
Oh, that gives the answer.
The government policy decision from. Because of the jurisdiction.
In TT কিবা আছে নেকি? In TT there is some. TT point আছে নেকি? Okay.
Government decision. Within the district of the accused person has been transferred. Even near cases also.
Okay, we need not say no.
Yes, yes, ma'am.
He has made us understand.
Election is coming with it.
We don't know.
Yes,
On many things,
yes, ma'am.
we are a bit hard of hearing.
Yes.